Today we are going to have a discussion on the transfer pricing litigation scenario in India, and we have the company of Mr. Riaz Thingna, who is a partner in Grand Thornton India LLP. Riaz has more than 30 years of experience in tax advisory and regulatory advisory services and domestic and international tax matters, including transfer pricing. He is an expert on FEMA advisory and is an advisor to many leading law firms in India. He is also the founding partner of Thingna and Contractor, a firm of chartered accountants with offices in Mumbai, Pune, and Delhi. He leads the industrial sector for the firm in the Western region. He has significantly worked with clients from diverse sectors, including auto, manufacturing, real estate, infrastructure, banking, and reinsurance. His expertise includes direct tax, inbound, outbound investment, tax advisory services, business restructuring, and international tax. As an introduction, I'm Vaishali, the transfer pricing partner, and I have over 22 years of experience in transfer pricing in Big Four as well as in Walker Chandyok. And I specialize in transfer pricing issues involving advisory, global planning, documentation projects, inbound, outbound advisory services for transfer pricing. I have also dealt with transfer pricing litigation matters and other projects such as mutual agreement procedures and numerous advanced pricing agreements. So Riaz, with this background, I would like to understand what has been your experience regarding transfer pricing matters in India. How is the transfer pricing litigation panning out in India?
Thanks, Vaishali, for the introduction. So, since the introduction of transfer pricing framework way back in 2001, transfer pricing has been a key focus area for taxation in the country, especially when it comes to M&Es. The practice of transfer pricing has gone through a complete cycle. M&Es initially brought in some bold measures, ostensibly to bring in tax efficiency to the overall structure. The revenue authorities, on their part, reacted with enhanced scrutiny and aggressive stance, and this had resulted in protracted litigations emanating from high-value TP adjustments on various recurring issues. But over the years, some progressive measures such as the adoption of global best practices relating to BEPS, the introduction of safe harbor rules, the APA program, the advanced pricing, additional guidance on mutual agreement procedures following a risk-based transfer pricing reference to CAS, has lent some balance in the approach. So the way I saw it and how it has been experienced in the early years of transfer pricing, we saw significant litigation as tax authorities scrutinized all forms of international transactions, right from the simple issues of selection of comparables to the more complex economic concepts. All this resulted in large-scale tax adjustments, created a lot of tax uncertainty, and M&Es proceeded with caution on their inbound investments. So being cognizant of all these ripple effects, the Indian government undertook certain steps to alleviate the concerns of such M&Es and MNCs by introducing safe harbor rules, risk-based assessments, along with the success of the APA regime, has actually reduced the number of tax transfer pricing disputes in India. In fact, the way things are going now, on the direct tax front, there's been an introduction of the faceless assessment scheme, and that has seen a lot of success and resulted in a lot of ease of doing business for M&Es in India on the direct tax front. So far, this faceless assessment scheme does not apply to transfer pricing regulations, but we expect that over a period of time, they will also be covered. And once they are covered, the mechanism will definitely ease the entire process in India significantly. So that's my broad experience over the years.
Yeah. And what are some of the transfer pricing pressing disputes which are impacting the MNEs in the current scenario?
There are various issues which have been coming up more often than others. So, as I was mentioning earlier, the tax authorities have been closely examining all types of international transactions. So, one of the issues is on this outbound intra-group service payments. Now, typically in large MNC groups, you have various charges which are made by parent companies and other group entities in respect of administrative charges, human resource support, IT support, uh, management services, etc. Marketing, technical services, R&D services, etc. And one of the most pressing adjustments is in respect of the benchmarking of such intergroup services. Basically, the transfer pricing regulations don't have clear guidance on how such transactions have to be treated. And that has also lent greater support to the confusion and to the litigation. Now, over a period of time, these payments, the transfer pricing officers, the revenue authorities had been typically disallowing these payments regularly on various grounds. One is that there's not enough proof of the service actually being received, or what is the actual benefit of the service, whether it can be quantifiable in terms of the recipient of the services. And finally, also, there's lack of, similar payments by comparable companies, etc. Now, these things are highly subjective because measuring the benefit from these services is always extremely difficult. Now, providing concrete documentation for the benefits is even more difficult. So sometimes these services are rendered informally, sometimes they are rendered through a documented trail, but there is always scope for argument on the total value of the services and exactly the value of the benefits received. And revenue authorities, therefore, have been disallowing various fees, especially management fees, on the ground that these are shareholder activities or duplicative activities. In the courts, there have been contrary decisions. So there are various tribunal, the High Court judgments, where they said that the transfer pricing officer or the revenue authorities cannot exceed their authority and they cannot question the commercial wisdom of the taxpayer. The commercial expediency of transactions is basically the domain of the management, and it should be left to the management to determine how best to run their business. On the other hand, there are various court decisions where the need for demonstrating the benefit as well as documentation of the services rendered has been upheld by the courts. And the intent is also sometimes questioned in some of the judgments on whether there is a tax incentive or not in the transactions being rendered. So with these contrary positions that have been adopted by various courts and tribunals, this issue remains open and it has been a subject matter of litigation over a long period of time. And I think over a period, taxpayers have also understood that there is a need to maintain evidence of actual receipt of the services, the need analysis of the need and the benefit that these services will render, and maintain service supporting documents. With that, the possible disputes can be reduced significantly. One other issue is also on the corporate guarantees. Now, very often, especially Indian parents of subsidiaries outside India may issue a guarantee on behalf of the subsidiaries. Again, a lot of decisions, courts have recognized that there is an economic reality that the parent company should grant corporate guarantees, primarily in furtherance of their interests as a shareholder in the subsidiary company. And some courts have therefore held that this would be shareholder activity, and therefore it should be, it gives a boost to the Indian company. In fact, a very interesting judgment has been that of the tribunal, the Ahmedabad tribunal, in the case of Micro Inc. Now, here it was held that the issuance of a corporate guarantee by the assessee on behalf of a subsidiary company is in the nature of quasi-capital. And therefore, it should be outside the scope of international transaction. It doesn't have a bearing on the profits, income, losses, or assets, and therefore it cannot be considered as an international transaction. But of course, on the other hand, there are various cases that which have held that the guarantee fee will be subject to transfer pricing regulations, as they have a bearing on the income or profits of the company. And courts over a period of time have adopted the ALP of corporate guarantee commission in the range of 0.5% to 1%. And the Indian safe harbor rules have also rationalized it at 1% per annum. So maybe this will put an end to the pending controversy on this count. These are some of the important points that come to mind immediately.
Sure. Thanks a lot. And would you like to touch upon the issue related to account receivables? Like, what are the precautions to be taken by companies when they are dealing with their group companies with service third parties? How can they control account receivables, credit period, whether this can create some addition for them, and what policy they need to have?
An important one that you've raised, Vaishali. Outstanding intercompany balances often catch the eye of the Indian tax authorities. On the one hand, the taxpayers contest that such outstanding balances are not a separate transaction, as they emanate from the main control transaction, such as the provision of service or goods. So therefore, there should not be any separate arm's length analysis. On the other hand, the Indian tax authorities seek to recharacterize such outstanding receivables as an advance or a loan extended to an associated enterprise under the garb of delay in realization within a reasonable credit period. In fact, some of these issues also have an impact on the exchange control regulations which are applicable in India, and there are certain guidelines on how they have to be dealt with. But the controversy around the outstanding balances being a separate transaction has been more or less settled with the insertion of a specific reference to receivables in the definition of international transaction under the transfer pricing regulations. So the focus has now shifted to the determination of the arm's length price for such balances. The Indian tax authorities generally compute notional interest on any such outstanding balance when they are overdue for payment. And beyond a reasonable period, of course, reasonable period itself is a subjective term. And the arm's length interest rate, what is the credit period which is normal for the kind of business, etc. These are issues which keep coming up on scrutinies. There have been various court decisions, both at the tribunal level and at the High Court level, on whether such extended credit period is subsumed into the working capital adjustment. Aggregation of the transactions on whether there should be a PP adjustment in the case of debt-free companies. But there has been even a Supreme Court decision in the case of Bechtel, where the Supreme Court has confirmed a lower court's order deleting interest adjustment on receivables, noting that the company, the SSE, was a debt-free company. So in the case of debt-free companies, maybe the controversy has been put to rest, but in all other cases, there is still scope for adjustments and additions which are being made by the revenue authorities from time to time.
And when we face litigation, we see that the tax authorities are keen to choose comparables which tend to have a very high markup. So generally the set that we receive, you will see that a lot of companies appearing in the set tend to have very high abnormal profits, which skews the entire result. Of course, because of the introduction of the percentiles, the effect slightly becomes low, but again, if all the comparables have high markup, again the results are very out of range. So what has been your experience about the abnormal profit comparables, and what is the legal scenario around that?
This comes from the fact that the Indian TP regulations do not provide for exclusion of comparables considering only the profitability criteria. And therefore, the tax authorities, of course, take a view which is most beneficial to the revenue. But even the various tribunals and the high courts have very often taken contradictory views. On one hand, exclusion of comparables earning supernormal profits has been upheld on the basis of abnormal profits arising from extraordinary operations. On the other hand, there have been various decisions where they've advocated the view that comparable cannot be excluded merely on the ground of earning abnormal high profits, and the functional comparability has to be seen. And I think, yes, to some extent, there are arguments in favor and against both positions, because various businesses are structured differently, and the functions and the risks of each arrangement is quite different, and therefore just one particular standard on whether we have to exclude or include super profits, companies having super profits, may not be justified by itself. So it has to be seen in the scenario of the actual business transaction, and as a result of which the courts have, again, various contrary decisions. Some are in favor of the revenue, some are totally against the revenue. So that controversy continues.
Yeah, thank you, sir. And we have also seen that there's a lot of dispute regarding the selection of tested party. Like in many of the cases, clients tend to select the foreign entity as the tested party and use foreign databases, comparables, etc. But we have seen a little bit of apprehension from the department side to accept this, who rely on Indian databases and Indian comparables. So, would you like to express your views on this topic?
Basically, a tested party is an entity whose profit margin is taken up for comparison, and the identification of a tested party is a crucial step in undertaking profit methodology-based comparability analysis for determining the arm's length price. The PP regulations again do not define the term tested party, nor do they provide specific use or prohibit the use of foreign comparables. However, the OECD transfer pricing guidelines and the UN transfer pricing manual have dealt with this issue in great detail. The OECD guideline defines a tested party as the one to which a transfer pricing method can be applied in the most reliable manner and for which the most reliable comparable can be found. It'll often be the one with the less complex functional analysis. The UN manual has also taken the standard clarifies that a tested party can be a local or a foreign party. Now, again, in the Indian scenario, there have been certain decisions, and the Mumbai Tribunal, for one, has allowed foreign associated enterprise as tested parties. Similarly, in fact, quite consistently in 2 or 3 cases, the Mumbai Tribunal has taken up the case that these parties can be foreign parties also. However, there are some advanced rulings also by court, and the Delhi Tribunal, for example, has rejected the foreign associated enterprises tested party, stating that the same lacks the statutory sanction and therefore rejecting the least complex entity argument of the assessee. So again, another issue which is open and being decided on a case-to-case basis by various courts and tribunals.
So thanks a lot, sir, for sharing your experience on transfer pricing issues in India. And hopefully, with the introduction of APM mechanisms, safe harbor rules, etc., to certain extent, certainty can be achieved. And of course, there are all new international topics which are developing on BEPS, etc. So we may have a little bit of respite to the clients on the transfer pricing front. But yes, the complexity and the confusion at times remains. So thanks a lot for your time and sharing your views today.
Thank you very much, Vaishali. In fact, as I said earlier, I think various measures are going towards reducing the controversies and litigation in India. Thank you.
Thank you.